I'm Christen Keller, Chief Program Attorney with Right to Bear. I want to talk to you all about something very important. It's a very common misconception that if you're innocent, you won't be found guilty, or that you wouldn't choose to take a plea deal if you're innocent or feel justified. And I'm here to tell you that's not the reality of our justice system, and that's why it's so important to have an attorney to help you navigate every step of the way from an incident to making these types of decisions or going to trial. Constitutionally speaking, you have the right to choose. A client has the right to choose whether or not they go to trial or whether or not they plead to a charge. As an attorney, as your attorney, I would help you through that. I would explain the pros and cons, but I couldn't make the decision for you. And the simple reason is if we go to trial and lose, I'm not doing the time for you. You are. It has to be your decision. If we go to trial and win, amazing, but it's also a huge risk that you're taking with your life based on 6 to 12 strangers, meaning a jury, depending on whether or not it's a misdemeanor or felony charge. So let me give you a hypothetical situation and see what you think you might do about it. Imagine that you have had an intruder try to break into your home and you have used deadly force to protect yourself. That intruder survives and then tells the police that he had been allowed to be in your home, and you, as you should, exercise your right to have an attorney present so you don't make any statements at the scene. Fast forward a little bit in this hypothetical, you go to a hearing and ask for a decision to be made, not by a jury. At this stage, it would just be a judge. You ask a judge to determine whether or not, under the law, the case should be dismissed. Under Colorado's Make My Day law statute, essentially, it gives protection to those in their own homes or guests in their home against an unwelcome intruder and to be able to use the force necessary to protect themselves. That goes to hearing, and then in those circumstances, a judge makes a decision. If the judge denies it, then you would go to trial. If a judge grants it, then the case is dismissed. Well, imagine in this scenario, you go to that dismissal hearing. You ask the court to take into consideration what happened and that you saved your life, and now you're hoping that he'll find, or she will find, that you are immune from prosecution. Imagine that the judge then says, after hearing what happened, I don't find what you have said credible. I don't believe you, essentially. So a jury can decide this later, but I am not going to make that decision now. And so what that means the motion to dismiss is denied, and now you're faced with a decision of going to trial. To make matters worse, before you have to decide whether or not to go to trial, the prosecutor has let you know that he is going to, or she is going to, add attempted murder charges and add sentence enhancers. The gist of that means if you go to trial and lose now, you're facing a mandatory minimum of 16, 20 years, potentially up to over 40 years in prison. Or you can plead to a lesser assault charge or battery charge, depending on what state you're in, and that prosecutor says you can do probation. What would you choose in that circumstance? What would you want your attorney to advise you? Well, your attorney can't tell you what to do, but your attorney can tell you that juries are unpredictable. I could tell you that you're risking time in prison versus having control of your destiny, so to speak. You have control over probation and what you do if you decide to take that plea and you stay out of prison, versus you go to trial and you risk your life to 6 to 12 strangers and you could potentially be acquitted and the case would be over and that would be amazing. Or you could be convicted and face mandatory prison time. These are the tough choices that you don't realize are out there until you're in the midst of them. And these are the really difficult situations that I see as an attorney every day, and I have had to help clients navigate consistently throughout my career. There are a lot of motivations for opinions on cases. There are a lot of motivations that clients can have, that prosecutors can have, that jurors can have. We're people, we're human beings. And you need an attorney, like a Right to Bear attorney like myself. You need an attorney that can help you navigate that and understand the possibilities, even if the reality is potential prison time. And you need an attorney that understands not only that you need to make a difficult decision, but knows how to be there for you and help guide you through that process. If you decide to go to trial, wonderful. We'll go to trial. I would fight every step of the way and do my absolute best, and we would prep for it. One thing you cannot prepare for, though, is the unpredictability of a jury. If you decided to plea That does happen more often than a lot of people think. It's also a completely respectable decision if you're ever faced with these type of dire circumstances. Thank you for listening to that message. And if you are not a Right to Bear member yet, please go to protectwithbear.com and check us out. If you are already a member and you've had an incident, be sure to reach out to the Attorney Answered Emergency Hotline. Thank you.